Recording in progress.
Okay. Now the bears. Let's clear this thing off. Let's go up to here.
Okay, so we're going to talk about estate planning and drafting a trust. Okay, here's the definition of estate planning. There you go. I want to control my property while I'm alive and able, take care of myself and my loved ones if I become disabled, give what I have to whom I want, the way I want, and when I want, while saving every tax dollar, professional fee, and court cost possible. That is the definition of estate planning, and that is the definition of having control over your stuff. And that goes from your house to your cars to your jewelry, guns, kind of everything that you own, gold, everything that you own. So the estate planning is about taking care of everything you own and everyone you love. And for people who are zooming in, most people, about 75% of Americans don't have an estate plan and 90% don't have disability provisions. Okay, so the big question I get on the next slide is, and this is interesting in California. People don't realize they call a trust a will. There's an interchanging there. In the state of Colorado, you have people do wills, and those wills can be extremely long, and they're the equivalent of a trust. I mean, they look like a trust, and you actually are able to usually distribute assets through a will, maybe in the state of California or in the state of Colorado. In the state of California, you cannot. So what a will does is it guarantees probate. You're handing the problems to your spouse and loved ones. It's having a will, but not a trust, is an unintentional disinheritance. So if a spouse is married, which a lot of people are married, in a lot of my probates, let me take a step back. Let me explain something. A will is a good thing, but a trust is a better thing, because in the state of California, you will be in probate court or having to hire me, and I have to submit the will to the court. And what the court does is the court says to me, Tracy, you don't have to now follow the probate code if the will says something different. Meaning that if the will gives to certain family members the estate, we're in the court are going to follow the will. But if you don't have a will, then you're going to be in probate court following the California probate code. However, just because you have a will does not mean that you're not in probate. Okay. And interestingly enough, I literally just finished last week a $60 million probate, and the gentleman was an attorney, and he wrote his holographic will, which means it's a handwritten will on a yellow pad. And the yellow pad it basically said, I give my entire estate to my uncharitable foundation. And he had a trust that was drafted. I mean, the guy was a lawyer, high-end lawyer, famous. He did all the tobacco cases. And his kids, he has 3 girls. His girls are being taken care of, but we did submit that holographic will to the court, and that's what we're doing, is we're transferring everything to his charitable foundation. So that's another topic at another time, but it's very interesting to see what we go through. You'd think somebody who has that big of an estate would have done that, but I actually think this gentleman knew what he was doing, and he didn't want to sign the trust because it was sitting there waiting for him. So everybody has a different role. Let me finish this little statement real quick. When you don't have a will or when you don't have a trust, what an intentional disinheritance means is that you are forced to, the person who steps up in their family shoes, they're forced to follow the California probate code. So when you have 2 spouses and you've been married for 20 or 30 years, the surviving spouse usually says, well, I'm going to get the house, I'm going to get the bank accounts, but guess what? That doesn't happen, because the California probate code says when you're a surviving spouse, if there's no trust and there's no will and there's no interspousal transfer by a spouse, meaning that would be a unique area, but there's no signing off on the spouse, the children get 1/3 or 2/3 or 1/2 of the property. So mom gets 50% of the assets, the other children get the other 50%. When we come across that, most of the time we have the children say, I love my mom, I'm signing over to my mom all of the assets, because she has She has to live her life the way she's accustomed to, but sometimes we don't have good kids. And so mom loses half of her assets. That is a big, or dad, that is a big deal. So when you have an unintentional disinheritance, sometimes the surviving spouse doesn't get everything that she's and her husband's been working for forever. Okay, let's go to the next slide. Without proper estate planning, we must involve the probate court to transfer property. The probate court will appoint a person with authority to sell real estate, which is the person that steps up in the person that is in shoes. You have to notify creditors and the state and wait a minimum of 4 months before the court can transfer clear title. Court involvement will generally result in added delay, expense, headache. So what happens is, and property owned in other states means we have to open a probate in that state. We have to do 2 probates. You do a probate in California, and then you have to, I'm doing one right now, and we're doing a probate in Nevada coming up because we have a condo in Nevada, so we have to get a hold of another attorney in Nevada. The cost of a trust, and we'll get into that, may be under $5,000 for average estate, and a probate's going to cost you an absolute minimum of about $12,000, all the way up to, of course, this large estate is in the 6 figures when you have to pay all the fees. So it's very expensive. The interesting thing also about a probate is it takes about a year. Trust administration will take about the same, but if it's a small trust administration, sometimes we can get it done within 4 to 6 months. So it just depends. What if I transfer my property by title? Another big issue in California, a lot of parents say, okay, I'm going to go ahead and husband and wife are married, husband dies. I usually just use the husband as the example. Surviving spouse, surviving wife is there. She does an affidavit of justice joint tenant. Not a problem, right, Janine? Mm-hmm. Okay, we file it with the assessor. The assessor says, okay, no problem. Wife still keeps her property tax basis, no problem. However, what we now have is we have one single person who, guess what? When they die, we're in probate. So what happens is a lot of parents, what they'll do is they'll transfer the property from mom, and then she'll put one of the kids or a child on as another joint tenant because they're thinking they're saving the property from probate. And on a case-by-case basis, that is fine. I'm not saying it's not okay, but there's a couple issues with that. My experience has been, even with bank accounts, you can do joint tenant bank accounts. I had a case, I'm just going, I think I've kind of experienced most of the things, although I think there's always something new every day that we get in our office. But I have a case where mom and dad were alive. Mom dies. Mom had joint tenancy bank accounts with daughter of 5 children. Dad wasn't on those accounts. Daughter kept all the money. So all the other 4 kids were out of $500,000. So there are issues with regards to transferring property by title. There's a risk of loss of property through divorce, bankruptcy, or lawsuit. It may not get to the intended recipients. Guess what? No, not all the kids got the money because we have a daughter who didn't want to do the right thing. There's a loss of basis step up. There's an unintentional disinheritance and loss of control of the right to sell or encumber. Let me talk a little bit about the step up in basis. And this is a big deal about trusts. But probably the most important thing, this is what I'm so grateful that the revocable living trusts are there, because what you get when you put your assets into a trust and your children inherit your assets, when you buy property at $100,000, maybe 20 years ago, your parents bought this property, and now it's worth $1 million. Most properties are worth $1 million in California, depending on where you are. That child inherits $900,000 of your step up. Okay, so they start their zero basis, or their start over, is at million, not at 100,000. They don't have to pay capital gains of 900,000. That is a big deal coming through a trust. In a joint tenancy, mom and son go on title. Guess what? Mom's done a 50% transfer. Son has got his step up right now. So if we transfer in 2022, son gets his 50% step up. And then mom keeps, they live up until 2030. Let's say mom passes away. Guess what? 50% of the property doesn't get a step up. There's capital gains on 50% of the property. So, I mean, people don't think about that. I used to think joint tenancy was awesome, and I still think it's great, but I do think there's other ways to do it. So,
Tracy, can I ask you a question, or
sure.
Would you rather take questions at the end?
It's totally your call.
What if, I mean, not everybody has children, right? And what happens? They just find the next person in the lineage of your family. But how can you, like, let's say you want to make sure that it goes to a charity, like you mentioned, you had a client. How can we need a trust to do that as well?
Yeah, so.
Because we talk a lot about children and family, but what if we wanted to go somewhere else completely?
So two scenarios in a probate, and we have those. We have people who pass away. They've lived in their home for 50 or 60 years, and usually it's a realtor that comes to me and says, "I just passed by this." I have one realtor that calls me and she says, "I passed by this house. It looks like a mess, but I found out the person passed away. I don't think this person has any heirs." What's going to happen is somebody, whether it's the realtor, the lawyer, we have to hire a private investigator to find a niece or a nephew or just an heir in another state. We'll have to file a petition for probate. Actually, the California courts have a probate division where if nobody steps up to the plate, they will probate the estate. Like it'll be a public administrator or somebody who's appointed to do that. But what we would try to do is we hire private investigators all the time. And we're looking for that heir. So that heir steps up, hopefully, and does the administration and distributes that asset then to that heir. If there are no heirs, which is rare, we will try to find a distant heir. I mean, it might be in Ireland, it might be somewhere else. We will try to find somebody to give those assets to, so we're not giving it to the state of California, because we all don't like paying taxes in the first place, and we don't want it to escheat to the state. I don't have a lot of that happen. However, there are a lot of people who are not married, divorced, or don't have kids. And we would also, the flip side of that is do a trust administration. And I'm thinking of what I'm doing right now, where that individual has given to like 15 charities. And so I'm doing this one client who is the administrators come to me, or actually it's two sisters, and the estate's worth $10 million. There's two properties in Newport Beach. I mean, you probably pass by this place if you're in Newport Beach every day, and it was owned by this individual and her husband. Husband passed away, and then she didn't have any heirs, so she gave to some family members, but then she gave the bulk of her estate to charities. People get to do that. There are things called charitable trusts, where you draft a trust that's specifically for charitable contributions. If you have a very large estate that's very high net worth, sometimes there's more than one trust drafted, where you're doing a revocable living trust, but then you also have a charitable remainder trust set up for the purposes of giving to charity. Does that help?
Yeah.
Okay, so I think we might have kind of a little bit gone through that. I will say, let's back up one thing. Transfer between family members, pay on death, beneficiary designations. Janique, do you see those still, the PODs?
Occasionally.
Occasionally.
Yeah.
In the state of California, I think it was in 2017, and a lot of other states, or at least there's other states that allow what's called a transfer on death deed. And it says transfer on death deed. And it's a new document in the state of California that the state of California said, okay, let's give this a shot. And so they did. They said, okay, you guys, if you guys want to transfer a piece of property on death to your heir, you can avoid probate and avoid having to draft a trust by just doing a TOD, a transfer on death deed. Well, I think what happened was they said they're pulling it. They didn't, like, they're saying that we're not going to do it anymore. We're going to actually phase it out. But now I think they're saying it's phased out not until 2030, or it's going to be a while.
I don't know about the phase out, but we've had issues where people have done them, but they haven't passed.
Correct.
And so it becomes an issue because now this person has to release their rights, sort of, because they were put on that deed to go back to the original person. So it gets a little complicated
Right.
Now that we're trying to deal with some of them, and those people might want to sell it, but
Right.
it was put in place, but it hasn't come to fruition, so
Right.
they're a little bit complicated.
They're complicated. So here's what's interesting, is a transfer on death deed has requirements. If you do a transfer on death deed, and you guys may have never come across it, but usually it works with one parent and one child. So mom transfers to son, there's no other kids, small assets, one house. She transfers to her son. The requirements are, you must record that, I believe it's within 60 days or like a very short period of time after you sign that transfer on death deed, it has to be recorded. If it's not recorded, it doesn't work, it expires, and guess what, you're back in probate court. So the problem is sometimes with these transfers via deeds or title transfers, doesn't work. If you just do a trust and spend a couple grand, it's worth it, okay? I don't care if you do a legal Zoom trust, doesn't matter to me, just, get a trust.
So Tracy, when it's transferred on death, does the property get reassessed?
Not to parent to child, but we're gonna talk about that because
Okay.
that's a little bit of, we've had a little change in California with regards to parent to child exclusions and grandparent to grandchild. Why can't I just give my property outright to my kids or loved ones? Part of it's because you've got predators and fortune tellers. Maybe your child, wants to buy a Lamborghini and they're 18 versus, going to college. Well, we have that. Spendthrifts, that's people who don't know how to stop spending money. Immature heirs, in-laws, you give to your son and it goes to your daughter-in-law. People don't like that. So creditors, it's true. Creditors, loved ones with personal struggles, minors, and people actually with special needs. People who have special needs, you're collecting Social Security disability income, SSDI or SSI, you're only allowed to have $2,000 a month in the bank account. If you have more than that, guess what happens? You lose your benefits. And you lose your benefits for a period of time based upon that inheritance. So if somebody gets a $5,000 check because they're getting an inheritance, or let's say it's $100,000 and they're not thinking about the fact that they're a special needs individual, which most people are clued in usually, they will lose their benefits for a period of time because the government's going to come in, the person that monitors that person's bank accounts and says, guess what, you've lost your benefits. So it's not quite one-to-one, but I'm not a special needs trust attorney. We need to have a special needs trust drafted. And in some of my probates, what I'm doing is I'm having to hire another lawyer. The client hires a lawyer. In a probate I have right now, 4 children, one of the children is special needs, or he receives SSI, not special needs, he's in his 50s, he's fine, but he receives SSI. He's going to inherit $126,000. He cannot touch it. So what we've done is we hired a special needs trust attorney who specifically drafts special needs trusts. In our probate, we've notified the court, and what's going to happen is when those monies get distributed, it goes right into the special needs trust in a pooled trust where somebody manages it for a ton of different people. And then that beneficiary doesn't lose their monthly income, but they also get the benefit of calling a trustee and saying, I need a haircut. I need extra money for food. I need extra money for right now gas or paying my electric bills. And they get to use those funds for specific things. You can't get a facelift on that money, but you can do other things. So estate planning basics, 4 types of estate planning: no planning, title-based planning, which is our deeds, will-based planning, which is what we've talked about, living trust-based planning. A better way to transfer property to my children is to transfer assets into a trust. It provides asset protection against creditors, divorce, and lawsuits. And if divorce happens, that's a whole other discussion, but your child can become a trustee of their trust at a specified age. That's really interesting. Surviving spouse is still able to benefit, and it stays in the family bloodline. So you have dynasty trusts, the Kennedys and the Rockefellers. I don't even know what they've got. I'd love to see their trust. They probably have 30 of them, all complex and all things that allow them to continue to hold their assets for the rest of their lifetimes. But for most of us, we're doing a revocable living trust, and we want our children to get the benefit of what we have worked so hard for. That's why I'm here. I got 2 kids. I gotta pay for their college, and I want to give them what I've done. I don't want it to go to the state of California. I don't want it to go to creditors. So the trust transfer those properties not only with hopefully the right property tax basis if my child lives in my home if I pass, and also they get a step up in basis through the trust because it's an inheritance. So okay, a living trust. It's a contract made between a trust maker and a trustee. And I'm just using a dresser. You can use a bucket, you can use a car. The dresser contains your guidelines and blueprints. The dresser holds your assets. And I'll talk a little bit about that. Go up 1. So a living trust dresser. When you are alive, you're the trustor, trustee. grantor, grantee. It's like calling yourself a doctor, an MD, a physician. They're all synonymous. When you're a trustor, you're also the grantor. As long as you're alive, you are in control of your entire estate plan. When you die, the trust becomes irrevocable. But a trust is revocable until you pass away or you lack capacity, if you don't have capacity. When you do a revocable living trust, what you get to put in your trust is everything you want. I have clients who've come to me and said, I've got 3 children. One of my children's living on the streets in Kamina, perfect example of this is real. And he's been doing drugs for a long time. We're going to put in our trust a provision that says if he goes into sober living and he's sober for 3 years, we are going to give him his estate, his assets. Or you can also say in your trust, my child, because they're a spendthrift, perfect example, my family trust, I'm giving you an example of my parents. 3 girls, and my older sister really loves expensive clothes. And we are going to be giving her a lump sum at some point, but we're going to be doling out money to her the rest of her life because I don't want her to come to me someday and say, Tracy, I'm broke. Because I'm not going to be broke. But the bottom line is it's called a lifetime trust. So you have the ability to control how your children get their stuff, which you might need to do that. You might need to say, look, I've got 3 kids, they're not the same. One's at Harvard, one's a mechanic, and one's at home, not doing great. And we have the ability to take care of all of them and have guidelines for all of them. So that's what a trust is. Okay, how can you choose who will make healthcare decisions and manage your finances? So to get served, let me, I'm kind of flipping to something different now.
Did you want to come back to it or do you want me to keep it on the screen?
No, we're actually okay. But what we also need to talk about when you do an estate plan is you're not going to just do a revocable living trust. You are going to have an estate planning package with you, the right attorney. So if you go to LegalZoom, and I have people coming to me with LegalZoom trusts, and I tell them, I will make this work, even though it's not great, it's 10 pages, mine are usually 60, which is overkill, but you'll never be in court with an improper provision with the trust that I draft through. But a lot of people don't realize when you do a revocable living trust, you need a power of attorney for assets, and you needed a power of attorney for health and advanced healthcare directive. So if you're capacitated, if you have lack of capacity, you have death without advanced planning. If a person's incapacitated, you'll face a living probate, which is considered a guardianship or conservatorship. At death, your estate may require probate depending upon the situation. So as an example, I had a client, they had a revocable living trust and the children managed it. Mom was in her, 90s, and she was starting to kind of lose it. And she, $12 million estate, pretty substantial, nice, but she was kind of losing it and she would only wear white. She had 30 feral cats in her backyard. The police, basically said, if you don't fix this, you're going to jail, to this older lady, and feeding the birds and all that. And she did not like anything black in her house. I don't know why, but this was a circumstance. So even though she was a very successful business person, as she was in her her whole life, as she started losing it, guess what her children did? They had to hire me to do a conservatorship. So even if you have a trust, sometimes because of the person's circumstances, it is case by case. Everything's case by case. You have to do a conservatorship. Sometimes we have assets where all the assets are in the trust, but then we left assets out of the trust. And we have to either pour assets into the trust, or sometimes when we have to do a conservatorship, those assets will go into the conservatorship, and then we have the trust assets. They're separate. But when we say without advanced planning that we might need a guardianship or conservatorship, the advanced healthcare directive will say in it, it'll say under a provision, it'll say, if by chance I need a conservatorship, my agent under this power of attorney shall be my conservator. So we basically have somebody appointed to have that conservatorship. Conservatorships are things, I don't know if you guys know what they are, but they're kind of like a living probate. You have to have it usually for elderly people. You're forced into it because, when I say you're forced into it, the kids usually come to me distraught because mom's acting crazy, or because no institution, she didn't plan or he didn't plan for their incapacity. There's no healthcare directive. There's no power of attorney. the kids can't do anything and they're forced into the conservatorship, okay? So right now, I've got a couple probates where, my clients are I've got a situation where the dad, the daughter, so mom passes away, she was the workhorse, dad, they have 3 or 4 kids, dad is having to file for guardianship over his minor daughter, because in a probate, you have to have a guardianship, so these things are just things that kind of come along, even if you have a revocable living trust, it's something that we do as, my office does conservatorships. Let's go.
So
ahead and
Tracy,
next
can I
one.
ask you a
Yeah,
question?
sure.
So somebody can set up a trust and have everything written out the way they want, but then one of your kids could think you're not well and have legal action for a conservatorship, which will then override your, that doesn't seem fair.
So let me give you that would be more of a detail. When a conservatorship is filed, and they're very, very complex, meaning they take a long time to file, a long time to draft, long time to file, because if you do it the right way, you're giving the court all the evidence it needs without having to like spend, go back and frantically file supplements. But what the court does is the court says, okay, Tracy, there's a revocable living trust, but you're filing a conservatorship. I am going to appoint 2 people. I'm going to have an independent person hired by my court to go visit that person who's the alleged conservatee. And I'm going to have them interview that person to see if they lack capacity, because I want to make sure that what you're alleging is really true, because if it's not, I'm not granting it. And then I'm going to appoint that person their own attorney. So there's attorneys on that sign up with the court. I haven't, I don't know how they're doing it, because it's just, we're too busy, but they're called PVP attorneys, probate volunteer panel, or court appointed counsel, CAC attorneys. And they're a rotating group of attorneys all over LA County and Orange County who get appointed to represent that conservatee, because when you're an attorney for somebody, your job is to vigorously fight for that individual. So that attorney's goal is to make sure that the conservatorship's needed and fight for the proposed conservatee, so that my petition won't override what that conservatee wants. As an example, here's what's really interesting, and we're getting a little bit off course, but it's interesting. Britney Spears' conservatorship was undone, right? The court said you don't need it anymore. There was a new law that came in, we call it the Britney Spears law. And there's a new law that came in just recently, and it's not good for us as lawyers. That basically says that you, as the attorney appointed for the conservatee, must listen to your conservatee even if they're cuckoo, and you must vigorously represent them for what they want. Now, that is problematic because, as an example, and the reason it's problematic is because sometimes a court-appointed attorney should be doing what's in the best interest of the conservatee instead of vigorously saying, because people who lose their capacity, their goal is freedom, not being controlled, not being restrained, not having a conservatorship. So some people who have dementia will fight the conservatorship even though they need the conservatorship. So what's now happening is we're going to litigation probably twice as much as we need to. And as an example, I have a daughter up in Northern California who called our office, and we're not representing her for a number of different reasons, but we did help her in the beginning, and we actually are helping her for free because they don't have a lot of money. But her dad's 94, lives down in Southern California. The attorney appointed in LA County to represent him is actually so egregiously wrong in what she's doing that she's created more problems than what she should have done. What she should have said, this guy needs a conservatorship. He's 94, he's got a ton of money. The daughter's the beneficiary, and I think the accounts are right. What I've been told is the accounts are now being overtaken by 2. It's a mess. Let me just say this. It's a mess. And the problem is that attorney, I think she should, I wish she should be investigated. She is not doing what's right for this individual. I had another conservatorship, and this attorney who was appointed, as an example, I represent the daughter. We filed for conservatorship. We had to litigate some of the issues, but that attorney who was appointed for the conservator right before this case did exactly what she should have done. She represented her client vigorously, but she really, really felt that there was a conservatorship that was needed, and it was given. And dad had a brain injury, and so he needed that conservatorship. So anyway, this is the little fun, what happens is we're giving you the overall, but there's all of these minute little issues that we have to deal with constantly as lawyers, whether it's litigation or whether it's the small issues of a trust. When you draft a trust, usually there's boilerplate provisions, but then we can draft uniquely for that family situation, and that's what I love about trust. Does that
So
help?
it sounds like we need to write in there who we would like to be our conservator. I mean, if we become incapacitated, so
Yes.
that we have somebody that we can trust and
Yes.
who will make decisions that are
Yes.
best for us. Okay.
And that's in your healthcare directive. So the advanced healthcare directive would have that. It wouldn't necessarily be in the trust, but when you have an estate planning package and you have a trust and you have the directive and you have this, usually the agents are the same individuals, so there's consistency, but at least you have those individuals identified. And for banking, it's easier. The banks are difficult. The banks will be a little bit more amicable. And the hospitals, that advanced healthcare directive is really helpful for them. For court, that's also helpful for them. So, I'm sorry I digress, but I can tell you stories and stories. The trust is not enough. We're almost done. You need an advanced healthcare directive. In my advanced healthcare directives, we have a HIPAA authorization, which is super important because you can't really do anything without HIPAA release. There's a power of attorney for financial affairs. You can do an immediate power of attorney or a springing power of attorney. A power of attorney springs alive when a person lacks capacity. I draft immediate because I don't want to get a doctor's letter to say my mom's not capable. I want it to be immediately useful. We need a pour over will connected to the trust. So if we have to do what's called a Hegstead provision and put an asset back in the trust, we can do it. We have personal property assignments. If we need a guardianship, the guardianship's identified. If we need a conservator, the conservatorship's identified. Okay, you want to coordinate when you hire a lawyer. What you want to do is you want to coordinate all of your assets. So when somebody comes to me, I don't just drop the trust. I usually say, okay, what do you have? They'll say life insurance. I have an IRA. Sometimes I have STIR. Sometimes I have PERS. And what I tell them is, okay, real property goes into the trust. Personal property goes in the trust. Brokerage accounts goes in the trust. Business interest, assignments of interest. Cars, I don't do cars. The reason I don't is because if you kill somebody in your car, guess who's the beneficiary? The car's in the trust. We might as well just carry super high insurance. I tell my clients 100, 300,000. Carry a really good policy, an umbrella policy, and you'll settle the case because most lawyers just want to sue and settle for their policy limits. Life insurance depends. If you don't, if you have kids, if you have a spouse, your spouse is first, your kids are contingent beneficiaries. If you don't have those kind of situations, the trust can be the beneficiary of a life insurance policy. However, annuities, no, IRAs, pensions, 401ks, no, not in the trust because we will then have major tax consequences. It is kind of nightmarish that when people put those assets into trust. So I, as the attorney, or just to make sure that I'm doing my job right. So when I close that case, I go, okay, they're taken care of in every aspect. In 5 years, if they do something I don't know about, not my problem, but I'm going to take care of them right now. We make sure that there's beneficiary designations, usually contingent beneficiaries and named beneficiaries, so that those annuities and everything's taken care of. When a spouse dies and a spouse receives an asset like a IRA, we then make them again try to have beneficiary designations, because if they don't and they pass away, guess what? We're probating their asset again. So it's,
Does the beneficiary on one of those accounts override a trust or vice versa?
Yeah, it's interesting because it's not really overriding the trust. It is literally outside of the trust estate. So when I do my trust, and even on bank accounts, you can go to the bank and say, I want my 3 kids to be beneficiaries of my bank account. Guess what? It's not in the trust. It goes immediately to those kids. It's an inherited asset. And I've had clients come to me who say, Tracy, I don't have a house. I just have bank accounts and I have this and I have that. And I say, you don't need me. Here's what you need to do. We'll draft a will because your assets are almost nothing. But go back to the bank and do POD or TOD designations. And you make sure there's a designation on everything and you're set. And that's what I sometimes tell people. They just, you don't always need a lawyer, but it depends on your estate and it depends on the circumstance. So that's it, guys, for that. okay, for trusts. That's kind of the overview. Let me talk a little bit about Prop 19, because we talked about that a little bit. If you'll excuse me, I'll paraphrase because it's a lot, but you have it there and you can move through it. California for, I don't know, the last 20 years, Tanique, I don't know how long, has had Proposition 58 and then Proposition, I think it's 193. And Proposition 58 was something that we all were so grateful for and loved, because what did we do? Is we had, if you want to flip through, maybe the next slide. So Proposition, okay, we'll talk about Proposition 19. Proposition 58 and Proposition 193. Proposition 58 is parent to child exclusions. Proposition 119 is grandparent to grandchild. We've all enjoyed the benefit since I was a kid of having a Prop 13 assessment, like small jumps up in our property taxes. And then if we die, our children will inherit all of our property in the state of California with the property tax basis that we had when we bought the property. So if somebody owns 10 pieces of property in California under Prop 58, and you passed away before February 16th or February, I think it was 16th, 2021, your children would get all of those assets with that low property tax basis. And what they would be required to do is they would be required to file the claim for reassessment exclusion. It's a BOE 58 form with the assessor, and they would get for each property, and then they would be able to say to the assessor, you can't reassess me, I get all these properties at this basis. That's no longer a lot. It didn't happen. We did something that we did a boo-boo in my opinion. So on November 3rd, 2020, we approved Proposition 19. What it was, technically, it was marketed as more of a wildfire relief act for people who lost homes in wildfires, but connected to it was also the loss of your they call it a California death tax now, but the step up in basis on your property taxes. That's out the window. So it changes the provisions on the parent-child and grandparent-child exclusions effective February 16, 2021, and it adds new provisions for base year transfers.
I know this has affected lots of people.
Yeah.
And I don't think many people know about it. You know, we think that we can transfer it, right, to our kids. The tax base stays the same, but that proposition really did it. And I know, Janique, you've been working so hard for us. She's invited the tax assessor here to our office a couple of times because it's still a little bit muddled, right? That
Right.
people are challenging it because it passed, just like she explained, undercover, right? Under pretense. And that's why we have to be very careful with how we vote, right? Because usually there's something that's fantastic that we want to pass, but there's always something, of the fine print that's at the bottom. And I think that, Tracy is saying, I think it was really a mistake because imagine we work so hard, we have our property. Why shouldn't we have the right to be able to bequeath that, right? To our children, to our grandchildren. And now we can't. I know you're going to go into detail on that, but I'm so grateful for Janique. And I know this coming week, right? We're always here at the office, like learning and keeping up to date with what's going on. And I know they're coming. When are they coming, Janique?
First week of October.
First week of October. Okay.
Yeah, there's a lot of kind of gray areas and situational questions that even the assessor's not completely sure on with this. But I know Tracy will kind of talk about it a little bit more. It was also built into the 55 and over where you can now move your tax base up or down. So that was the plus. The minus was the parent to child part of that law that went into effect, which has been a disadvantage for people that have multiple properties and can't let their children take over that tax base. So
That's good. So the San Bernardino County assessor, when I spoke to them a couple of weeks ago, and we were calling, we call them constantly, so I'm on the phone with them. They're actually really nice people, the assessors. But even the assessor said, Tracy, we are still waiting for instructions on what to do with some of this. So everybody's trying to figure it out. The Howard Jarvis Taxpayers Association is trying to repeal this. I have no idea if it made the ballot. I think in November. I need to check. I don't know. Maybe I don't know if it will be repealed or if it will be edited to be more kind. I have no idea. But what has to happen is when you have your primary residence, either your child is going to move into that residence and live in that residence, and then file what's called a Prop 19 exclusion for that residence and to say to the assessor, I'm living in the home, which means that child kind of falls under the Prop 58 exclusion. They get the property tax basis low. If one of the children, let's say you have 3 children, if 3 children are inheriting a piece of property, I think as long as one child lives in the property, the assessor will still allow it, even if 3 children own the property and 2 don't live in the property. But you have to live in the property. If you don't live in the property, and this is what I'm telling my clients, you're going to have to either sell or you're going to have to understand that you're going to have an increase in the property, your property tax basis is just going to happen. Okay, so Prop 58 the effective date was November 6, 1986. It transferred the principal residence between children without reassessment regardless. No restrictions on the use of property with a transfer up to $1 million. With regards to other residences without the reassessment. So you still have, I mean, if you have multiple properties and they were worth more than $1 million, you still would get an exclusion of up to $1 million. So that your primary residence is excluded, but then up to $1 million, all those other residences would have been excluded. So maybe somebody who owns 2 or 3 homes, they would have fallen under that $1 million exclusion. And that requires paperwork going into the assessor saying you cannot reassess me. You know, lawyers do that. You cannot reassess us. We're under the exclusion. Here's the proof. Please don't touch this. And they process it. I mean, that's what they do. They process paperwork.
And just to give you an idea, let's say a property that's worth like 900,000, right? The property tax at a reassessed value of 900 is almost $12,000. So if somebody inherits the home, there are people who can't keep up with paying $1,000 per month, right? For property tax. And many of these homes were bought maybe at 26,000, you know. So it's definitely a big jump, and it's taken away, you know, it's kind of eroded that whole Proposition 13 that we so are grateful for, right? That the property tax is more predictable.
The next slide is just grandparent and grandchild exclusion. Oh, there was a slide up. That's okay. Prop 193.
Oh, sorry.
No, it doesn't matter. Prop 193, grandparent to grandchild, that exclusion was allowed. So it's the same thing as Prop 58, but that's not allowed anymore. So if you flip down to the next one, the Prop 58 and 193 says transfer principal residence between parents and children without reassessment regardless of value. Now Prop 19 says the value limit of a current taxable value plus $1 million. So there's going to be a calculation from the assessor on how they're going to recalculate your property taxes. There were no restrictions on use of property after transfer. Then now the transferee must use the property as a principal residence. Before it was transfer property up to $1 million in assessed value. Now only the principal residence is eligible. It eliminates exclusion for other real property. And so and I think I'll probably just do the 55 and older, and we'll stop there.
Okay, sure.
But what's interesting is families who have Beverly Hills properties who are worth 10 million, I mean, homes in Beverly Hills, 10 million, 20 million, 5 million, you know, these are dynasty homes where these families have transferred these homes down in Beverly Hills forever. And then now that the parents have passed away, the children inherit that property. If they don't live in the house, that $20 million home gets reassessed up to the current property. They can't keep the property. So what it is it creates maybe more business for realtors. That Howard Jarvis Taxpayers Association calls it a death tax, because what it is we're collecting more revenue based upon the fact that the person has died. Otherwise, what's happening is the property has to transfer to new owners, to new ownership. Okay. The rest of this is just showing calculations. I'm not sure that's that important. The only thing I would say is on Prop 19, and I can go through this with you guys if anybody has questions more. Homeowners who are 55 or older, who are severely or permanently disabled, who are victims of a disaster, there's certain categories. Wishing to transfer the property to a different county, there were like maybe 12 counties before this who participated in this kind of reciprocity in terms of keeping your property tax basis. Now all of California is covered. So if you move from Orange County all the way up to Eureka, you can buy a property that's of equal or lesser value, but now it used to be equal or lesser, now it can be of greater value, and you can keep your property tax basis and move it. Okay, there will be a slight recalculation, but at our last meeting, people said, well, how do you do that? And I pulled this up, and it's basically just a form. It's just a document that you file with the assessor, that you fill it out and you say, I want my property tax basis to be applied, and the assessor will do the research and give you that property tax basis. Okay, so that's one thing to keep in mind. If any family member or parent is going to move counties, you need to make sure your property tax basis gets moved as well. Okay, that's Prop 19 in a nutshell. Again, I still don't have all the specifics. What we do as lawyers is we do the best we can to work with the assessor to make sure that if somebody dies before February 16, 2021, because we still have people passing away before then, we get the Prop 58 exclusion. But after that, we need to advise our clients that either you sell or you need to live in the property. So that's kind of it.
Great.
Okay.
Well, I would like to be able to,
Can I
yeah,
say
ask
something?
questions,
Sure.
please.
You just said you still have people dying before February 16th, 2021.
No, what happens is the children have parents who passed away, and they stick their head in the sand and they don't come to anybody until 4 years later
Oh,
or 5 years. I have clients that came to me 10 years later. Mom died in 2012. We did a probate. The capital gains on 10 years of increase are going to be, I mean, luckily some of the kids don't make that much money, so their capital gains may not be as high, but they wouldn't have paid capital gains had they sold the property in 2013 or 2012, 1 year after mom's death. Now there's major capital gains, and you could say, well, the kids got the benefit, I mean, of all that increase in value, but there's going to be capital gains that they have to pay. So it just depends. But people have passed away prior to 2021, February 16th, and we will still probably be having people come to us for a couple of years from now who have not dealt with their issues.
But they're protected if they died before February.
100% protected. We just have to
Okay.
provide a death certificate.
I
So,
see.
yeah.
Okay.
So I hope that does it for you guys. I hope it's a lot of information, but I hope it made sense. So, okay. Great presentation. Thank you. Thank you very much.
Please ask your questions. Sometimes we came here with certain things in mind, right? Things
Yeah.
that, please ask, the question and,
And she
she's an
covered
attorney.
that.
Some things aren't, sometimes we need an attorney. Sometimes we might just need to record something on title. And so we can cover you for both bases, right? For both
So
situations.
my questions were about the capital gains
Yeah.
and also what to leave in, to put in the trust and what to leave out.
Okay.
I had questions about that. And I knew somewhat about the Prop 58 because I have a friend who is going through this right now and she wanted to give the house to her grandson.